All right. Hello there. Dudley Brown here. And we're starting our Facebook Live video here. We'll give a few minutes for everybody to get connected. If you're watching this at home or at work or on the road, hand the phone to somebody else. But click the little link that says host a watch party. And I know that's kind of a new thing for many people. It certainly is for me, and I've been using Facebook for years. But it actually has a link that says host a watch party, and that helps us share to other people who are not involved, who are, kind of care about the issues, but you want to get them more involved. This is a great way to do it. And the so click on that, host a watch party. While you're doing that, while we're waiting for other people to join, we also want to get kind of a idea of who's watching and where you're watching from. So, like, post your city if you're watching this from whatever Timbuktu. If you're watching it from any part of Colorado, or frankly outside of the state, there are a lot of people who care about Colorado politics who live in other states or are traveling for work. But tell us where you're watching it from. If you're on vacation and you saw this, shame on you for not enjoying your vacation. No, we're happy to have you, and we want you to share it and tell us where you're from, watching from, and again, host a watch party. So I'm Dudley Brown with Rocky Mountain Gun Owners, and I wanted to talk to you today about what we're doing right now about the red flag law. And what our hope is that it isn't a law in Colorado, that we can circumvent that. And we'll explain what we're talking about in just a moment here. Now, I'm going to be joined by two people in a minute, but I'll give you an idea of the agenda. We're going to talk about the lawsuit itself and what we're doing and the differences with our other lawsuit. And we're going to bring in the House Minority Leader, State Representative Patrick Neville. And Patrick is, I'll give you his introduction in a minute, but he's a young, interesting guy who really is on our side and a fighter. And then we're also going to bring in our attorney. I know he went long he might have been actually in court, Barry Arrington. And he's the attorney who filed this lawsuit on red flag. And then we're going to kind of bat it around like a talk show and talk about what this all means. And of course, I'm going to learn something, because anytime Barry talks about the legal process, I learn. And frankly, anytime I can get somebody who's on the inside like Patrick is, and making the sausage, so to speak, or trying to stop the sausage from being made, I learned something too, even after my many years of working with the Colorado legislature. So there are two lawsuits, and I want to make sure we're not confused. Rocky Mountain Gun Owners has a lawsuit that we filed in 2013 when the normal capacity magazine ban was passed in the Colorado legislature and signed into law when it enacted in June of 2013. That lawsuit wound its ways through the courts and is now being heard by the Colorado Supreme Court. Our hope is that it overturns the magazine ban and gets rid of the magazine ban in Colorado. Now, is that a hope and a prayer? Well, we've invested a lot of time, a lot of effort, a lot of brain power, and a lot of money in all of that. And many of the people watching this are RMGO members, and you've donated to that. You've been a part of it. I want to thank you right now, because that's really important. Can we win? I don't know, but we had to push hard and try and overturn this magazine ban. Well, that is going to be heard with oral arguments in the Colorado Supreme Court, and based on our Colorado Constitution. So that's as far as it can go. It can't go to the U.S. Supreme Court. And in September, it's going to be heard, and we think we might get a decision by the end of the year. Of course, we're all hoping for a perfect decision, which is to strike down the magazine ban and return us to some semblance of freedom in Colorado. However, that is not what we're talking about here today, where that's going to be for another show. What we're talking about here today is a lawsuit Rocky Mountain Gun Owners and some state legislators banded together to file right at the end of the legislative session that would overturn the red flag law that was passed in the 2019 session because it was passed unconstitutionally. And so I'm going to ask my guest, State Representative Patrick Neville, the minority leader in the House, someone who stood toe-to-toe with gun banners in the legislature and did everything he could to stop them. Thank you, Patrick, for showing up. And Patrick, you know what we're talking about. Let's assume that everybody watching isn't up to speed. What is this lawsuit? You know, why did we file it? Because something happened in the legislature. Why don't you tell us?
Right. So it's pretty simple. The process that we have in the state of Colorado is any legislator can actually ask that a bill be read at length. When that happened, when we were hearing red flag in Colorado, it was Representative Steve Humphrey who made Representative Dave Williams who made the first request to read it at length. They said he didn't properly move it, but if you look at the tape, he clearly properly moved it. And then Representative Steve Humphrey came up and moved it again. And not only did he say read it at length, he said in a clear and intelligible manner, at which point they began reading, but then they brought out several different clerks. They all started reading different sections of the bill at one time. So Representative Humphrey came to the well, withdrew his request, and said, I certainly didn't mean to create a cacophony, and that certainly wasn't intelligible. So the debate continued on, and after a while, Representative Lori Sain came up and made the same request to read the bill at length. The chair ruled that out of order and said it had already been considered and will not be considered again. The key here is this has already been litigated on a different bill in the Senate. The Senate had something happen similar earlier in the session on a much longer bill. It was 2,000 pages, over 2,000 pages when they did this. They actually appealed that. It went to court, and the Republican Senate won that. And it was ruled that the bills have to be read in a clear and intelligible manner if requested by any members. And the Constitution outlays that really clear as well. So they violated this. Not only is the bill unconstitutional in itself, they actually used an unconstitutional process to pass it. And I think it's only important that we stand up against that kind of overreach. This is something that we have as citizens to make sure that bills aren't flown through really quickly and that we can utilize at any point, and they violated that in the process.
And when we get Barry on here, hopefully his court didn't run too long. We can have him kind of cover why we filed what we filed, but why? Many people think, why did the Colorado Constitution even have that in law? Why is it written that way? And I think Barry will can share a little bit of the research, but and there he is. So I'm going to invite our attorney who filed this suit, if he can get his camera figured out, Barry Arrington, who live from I think Aurora, Colorado. Well, we'll wait just a minute as he gets it all squared away. Remember that many legislators weren't able to weren't able to read when the Colorado Constitution was written. Talking ranchers and farmers and really pioneersmen who settled this area. It was a pretty tough area to live in. You didn't have any water out in the eastern plains unless you diverted it, and that was difficult, and especially before the days of machinery. So they had to read the bills at length, or you didn't really know what was in them. So let's bring. I think he's ready. Let's bring Barry Arrington onto the mix, and he can answer some of the questions. Barry, can you hear me?
I can hear you, Dudley. Thanks for having me on the show. Sorry for the technical difficulties earlier.
I know you're a Luddite, so
I was out breaking racks. That's why I was late.
Barry, what Patrick just talked about what happened in the legislature, and I'd like you to talk about why that's a problem. Why is it a problem that they didn't read it at length?
Well, the Colorado Constitution is very clear on this issue. There's a provision right there in the legislative article of the Colorado Constitution that requires every single bill to be read at length. Now, there is a rule in the House of Representatives that says that if there is unanimous consent to dispense with the reading at length, then that can be waived. But if even one legislator wants the bill read at length, the Constitution requires it to be read at length. And the Colorado Supreme Court has held in no uncertain terms that the provisions of this article of the Constitution are mandatory. And any bill that is passed in violation of the terms of this provision is null and void. And therefore, there's a procedural infirmity with this legislation. Not once, but twice, it was asked to be read at length, and the majority party absolutely refused to comply with the Colorado Constitution. Now they filed a motion saying, well, we should just ignore the Constitution because it's outdated, it's no longer relevant. But that's not how you work in a society that's ruled by the rule of law. If you want to amend the Constitution, you don't just ignore it. You put it before the people and say, we don't think this is a good idea anymore. What do you think? But if it's in the Constitution, you've got to follow it.
That's right. Well, and I remember that when we did this news conference at the end of the session to announce the lawsuit, I remember one of the reporters said, isn't that just a technicality? And I kind of chuckled, and I know you did, Barry. You said, well, you think the Constitution is a technicality? I mean, and then I jumped in and said, yeah, the First Amendment is just a technicality. Next time you guys go use that to protect your First Amendment rights to publish what you're doing right now, just call it a technicality and dismiss it. You'd be okay with that, wouldn't you? And of course, many of them went, oh, huh.
Yeah.
So while we're doing
in terms of the Constitution, the Fourth Amendment is the one that's accused of being the technicality the most. Okay, there was a flaw in the police's warrant, and where they busted down your door and searched your house illegally. Well, it's just a technicality. We got you. Well, no, it's not a technicality. It is designed to constrain the government. And whenever the government doesn't follow the Constitution, it's not a technicality. It is the law of the land.
That's right. By the way, so we're asking people to click on host a watch party and then also post your questions and then comments. One of the questions here, which I think pertains here, is said, aren't you going to file a lawsuit based on red flag itself being unconstitutional? And I think, Barry, my answer to that is, yeah, that's step number 2, if we get to that.
That's right.
And there are some problems with that. One is, where in our court system that you file that. Remember, this is happening all around the country. Red flags is happening where it's happening in state legislatures that we're tracking here at NAGR all around the country. But here's the other concern is you got to have a case against it. So you have to have somebody who was harmed. Is that true, Barry? We would have to find somebody who was, quotes, red flagged?
So the thing about the red flag law and any law that you're challenging is you have to have standing to challenge it. And in the case of a substantive challenge to the red flag law, the state would move to dismiss unless you have someone who's saying that they have actually been red flagged, or there is a reasonable possibility that they're about to be red flagged. Until we have that person, it would be tough to challenge on standing grounds.
Yeah. Well, and so, okay, they didn't read it at length. Patrick, I mean, come on. That's what the reporter said. Come on. It wasn't read at length. So, I mean, what's the big deal? I mean, isn't that just you guys being nitpicky?
No, not at all. It's actually done quite a bit. And for us, it actually gives us a bit of a protection in state law that they can't rush things through without us even having a chance to read it. So we used that. They clearly ignored it. They clearly ignored the Constitution. Not surprising, because I think the law in itself is unconstitutional, but this is one of the ways that we can actually fight this law. And like you, I want to fight it every step of the way. I fought it when it was getting passed, and now I'm here standing with you fighting against it once again.
Yeah. Well, there will be some people who throw rocks no matter what you do, even on our side. And to them, we just say, do what you want, but we're going to fight this every way we can. This is just one of the steps. And it was one that some legislators, Patrick and Lori Sane and Dave Williams and Steve Humphrey all came, did the hard work in the legislature, but then said, hey, we don't think they followed our Constitution. And Barry said, yeah, I don't think so either. Now, Barry, I know I've had a lot of, quotes, legal experts come to me outside of you and say, there's no way we can lose. But of course, I'd be a very poor man if I bet every penny I ever had on winning every time a lawyer said it was a certainty. But you do give this good chances, don't you?
I think that if the court follows the law, that it's a certainty that we should win. The problem is courts as don't always follow the law as it's written, and they dream up ways to get around it, and so I think that we have a good chance of winning if the court follows the law.
And while we're on this, Barry, I'd like you to the governor, through the attorney general, filed a response on last week, and that was their deadline on the 27th. So their response was basically a motion to dismiss because because what?
So they've basically said that the Constitution is outdated and we shouldn't follow it. I mean, that's pretty much their main argument. They also say that no one has any right to challenge the legislation because nobody's harmed by the majority party's failure to abide by the Constitution. And get this, one of their arguments is that the legislature or the House of Representatives should be the one that is the plaintiff in this case. But of course, the majority in the House of Representatives is controlled by the people who were the wrongdoers to begin with. So they're saying that the wrongdoers should control whether a suit is brought to address their own wrongdoing. And finally, they say, well, you waited too long, you didn't stop us from doing it, and therefore you don't have a case. It's like you allowed us to do it, sort of a response. I think we have good responses to, or good answers to all of those objections, and hopefully we will prevail on this motion to dismiss.
Patrick might get a chuckle out of this. I had a Denver Post reporter ask me about it, and my response to part of the governor's response was, which said, you didn't work with us within a certain time frame, and you weren't trying to make it all work together with us, and which is kind of like you opposed the bill and you did everything you could to oppose it. Really? That's something new in the legislature? I'm pretty sure the Dems have done that many times.
Right. That's what I was elected to do, to fight for the constituents of my district and to actually oppose things with every procedural move we have. This is one of those moves that we do have. It's clearly written out. It's something that's willing to protect us as legislators so that the minority actually does have some say in the process. Unfortunately, the majority just completely ignored it. So to say that we didn't work with them, well, they didn't exactly work with us either, because they just would have read the bill at length.
Right. Well, and then the question of you didn't collaborate with the Dems on your strategy. Now, anybody who's been involved in the state capitol for about 5 seconds knows that in the different parties and sometimes even the different chambers, even if they're of the same party, they don't always collaborate well. And frankly, they're not supposed to. The whole idea of checks and balances is that there's this tension that will create some kind of equilibrium. And part of that is you have your own strategy and your caucus has its own strategy. And frankly, you as one single member have their own strategy to represent your constituents the best. So,
and that's correct. The idea that the parties and the chambers can obstruct one another it's a feature of the system. It's not a bug.
It's a benefit.
That's right.
It's a benefit in many ways. I use the filibuster in the United States Senate as a great example of a feature that was put in that actually benefits the American people because it slows everything down. Frankly, gridlock is pretty good when they're trying to change our entire country around and turn it into something else. That's what our founding fathers designed it to stop, is they didn't want that radical change. So,
right. And I see a question from Tim up there. That's
Yeah.
a great question, Tim. What did the Dems do that was so terrible? Well, they flat out ignored not only House rules, but they actually ignored the Constitution when they were passing this bill, because not once, but twice did they refuse to read the bill at length. And this is not something that's hard to do. Here in Colorado Chamber, they can do it electronically through a machine in an intelligible manner. It probably would have cost them maybe 30 minutes of time, but they denied that request twice. They were so eager to ram through this unconstitutional bill that they ignored constitutional protections that we even have in the procedure of actually passing a bill. So they just completely ignored all proper protocols because they wanted to see this thing get through and they wanted to do it quickly.
Yeah. Barry, where do we go from here?
So the motion to dismiss is pending. Our response to the motion to dismiss is going to be filed later this month, and then the court will decide whether the lawsuit goes forward. And if the lawsuit goes forward, and I expect that it will, because motions to dismiss are tough things to get passed. They're disfavored because it basically cuts off the entire judicial process at its very beginning. And so the motion to dismiss will probably be denied. I can't guarantee that, but it will probably be denied. And then we will go forward with adjudicating the whole situation of whether the majority party gets to run roughshod over the rights of the minority party and the provisions of the Constitution in later stages of the litigation.
Well, and even another reporter even suggested to me that to a large degree, the governor agreed that that what we claimed actually happened. So they kind of said, yeah, it happened.
Well, at this stage of the litigation, they have to, because we can't adjudicate factual issues. But nobody disputes that it was not read at length.
So Connie Hull says, seems like Democrats and some rhinos, Republicans in name only, don't care about following laws or the Constitution of Colorado or the U.S. Well, yeah, welcome to politics. No doubt about that. My comment to many of the reporters when they asked about the governor's response was they used an unconstitutional process to try and restrict your rights unconstitutionally. Now, of course, we believe red flag laws in themselves are a violation of the due process protections built into our system and should be ruled unconstitutional themselves. But right here, we're digging into, hey, they passed it unconstitutionally. They violated the Colorado Constitution in doing so. Barry, you're a betting man. I know you are. I've been to Vegas with you many years ago. How much scratch do you put on the table on this? You think we got a shot?
We have it more than a shot. As I said, if they follow the Constitution, if the courts follow the Constitution says that you have to read it at length unless there's unanimous consent is waived. It's very, very clear, and the only way and it's indisputable that unanimous consent was not present, and therefore the mandatory provisions of the Constitution were not followed. It seems to follow that we should win. And so that's what my position is right now. We ought to win. Wouldn't have brought the case if I didn't think we ought to win.
Let's play a what if game. Patrick, what if we win and the judge says, yep, they failed to follow the Constitution. This law is void in Colorado. Boom, it's done. Instead of being enacted in January of 2020, now it's not enacted at all. What is that? That forces the Democrats to what? They're going to have to either run it again or give up.
That's right. And they'll have to run it again in an election year. They wanted to pass this quickly and smoothly, hoping that voters would forget about it for the next election cycle. I don't think they will. And if they have to do it again in 2020, that's something that's going to be fresh in the voters' minds. Another possibility is you're hearing rumors of a special session already down here on a different topic, but they could include that as part of a special session.
Well, let's talk about that. First off, the question is, do they really want to face this in an election year? Some Dems think this is a good campaign issue. They think the people are with them. the one thing's for certain: the gun community is very much against them, and they don't want to activate our base, so to speak. But to throw out that possibility of a special session, Patrick. Um, tell the watchers what this looks like. Doesn't the governor have to specify that in the call?
He would. A special session can be called, and there is no time length it has to be limited to, but it does have to be limited to actual subjects. So right now there's talks that they might actually call a special session to take away your taxpayer bill of rights refunds that you're going to be getting here soon. But on top of that, they could add red flag to that. I don't think they would want to do that because they probably don't want that much attention to this one single subject. But ultimately, you know what happens, Dudley. They get their marching orders from Michael Bloomberg, and they're going to want his money to keep pouring in here. So if Bloomberg gives the order, that's a definite possibility.
Yeah, this is. I started working in the Colorado legislature, actually working for the Republicans in the House in the 1990 session, and so I've seen a couple of legislative sessions, and no, they really don't want to deal with this, but they might be forced to. Here's a great question from Sean. He said, "Can the Supreme Court or any federal court step in and stop a state government from breaking the laws of our Constitution?" Barry?
So the answer is, if the matter rests solely as a matter of state constitutional law, the federal courts don't have jurisdiction. This Colorado Supreme Court is the highest authority in the world on interpretation of the Colorado Constitution.
And that's what we filed on this lawsuit. We filed it's a violation of the Colorado Constitution, not the federal Constitution.
That's right. And if there were a substantive challenge brought, it could be filed under either the Article 2, Section 13 of the Colorado Constitution or the Second Amendment in a federal court. But this one is a state court matter only.
Okay, that's just a reminder. That's what we did with the Colorado magazine ban. Was we filed against the magazine ban to try and overturn it based on the Colorado Constitution, Article 2, Section 13, which means the only real way it can be overturned is by the Colorado Supreme Court.
That's right. There was
the final authority.
There was a Second Amendment case brought, and it lost in the federal district court. And that case, that was actually vacated by the 10th Circuit. So the Second Amendment challenge to the mag ban went nowhere. We're still fighting 6 years later in the state challenge.
6 years later. I mean, I'd really like it to be done by the end of this year. Although it wouldn't hurt my feelings if they didn't ruled in our favor in April of 2020. So it doesn't give them enough time to run a magazine ban again and try and fix it. Unfortunately, the danger with that is that some of the people like Dave Kopel would try and manipulate and advise the Democrats on how to pass a constitutional mag ban. But I digress. That's another story, another live. One more. Jacob asks, how can states continually violate constitutional laws with no repercussions, i.e. red flag law and fracking laws? Well, Barry, you want to take that?
Well, the answer is that it's a fundamental difference between conservatives and liberals. Progressives, I should say. Progressives don't care what the law is. They are in it for the pure exercise of power. And it actually goes down to worldview issues. Progressives are by and large materialists, and they think there's nothing in the entire universe except matter and motion. That issues of truth and justice and beauty and these sorts of things that we all hold dear are simply preferences that hairless apes have evolved to prefer. And so ultimately they don't really care because it's not ultimately meaningful to them. Conservatives, by and large, believe that there really is such a thing as objective morality, as objective truth. Certain things are objectively wrong, certain things are objectively right. And that's the reason that progressives don't care what the Constitution says. Woodrow Wilson was one of the original progressives, had an affirmative plan 100 years ago to basically overturn the entire Constitution. And he succeeded. And his progressives after him have succeeded to a large degree. And the only way that can happen is if people elect them to office over long periods of time. And so that's the answer. The country in a republic like we live in goes the way of the majority of the people over a long period of time. And the reason we're in the fix we're in is because this whole idea of objective truth and objective morality has waned over the last 100 years.
That's right. I'm going to end with Joyce here. She asks, her comment kind of is, this is all fine and well, but what is RMGO going to do to win elections instead of just arguing about one bill at a time? And I'm sure Patrick would likes to hear that talk. I certainly do. Joyce may have missed the earlier comment, that I made, which was, this is just one stage in the fight. And so it doesn't mean we're not going to do other things. Of course, we're going to do other things. We're working on a number of areas to fight red flag. And in this case, it all comes down to who you elect. Because if we had elected Patrick Neville here as the Speaker of the House, and had, at least had one chamber, or had two chambers, or even better yet, had two chambers in the governor, we could have done a lot of things like pass constitutional carry and repeal the magazine ban. Yes, of course that's important, but that doesn't mean you stop lobbying against bills in the legislature. I mean, yeah, you got to win elections, but you still try and stop legislation. And I have a news flash: even if we elect Republicans into control of the House, the Senate, and the governor's office, doesn't mean we're going to get good legislation. There are many states where that's the case, and Republicans have enacted red flag itself. Florida is a great example. In fact, Florida ushered in a ton of gun controls under Republican leadership. So with that all being said, as an organization, we fight on many fronts, and this is just one of them on the legal side. Of course, we'd like to win them all and waive the Second Amendment and just say that nullifies everything. Well, that hasn't ever worked for gun owners. And I mean, even as a lawyer, I don't think Barry advocates that.
The best way to fight gun legislation is through the ballot box and electing people who understand and respect the right to keep and bear arms. And keep in mind also that the right to keep and bear arms does not exist because the Second Amendment exists. The Second Amendment exists because the right to keep and bear arms was what the lawyers call a pre-existing right. And it was just codified in the Second Amendment. It is a fundamental aspect of the natural law. And if you put people in office who understand that, then you're not going to have these problems. But if you don't, we're going to be fighting these rearguard actions all the time.
Yep. Well, thank you, Barry, for joining us and for doing the work in the courtroom. I, for one, can say I don't know of anybody more qualified to make constitutional arguments in this state than you. And I want to thank Patrick Neville and frankly, many of his caucus, almost all of whom are pretty solid. There are some weak sisters there, but Patrick leads a pretty solid conservative caucus, and it's great that they were willing to stand up and say, Lori Sain and Dave Williams and Steve Humphrey and Patrick were able to stand up and say, no, well, let's see if we can stop this here because they didn't do this right. Thank you both, and I'm sure we'll do another session with you on another day.
Thank you very much.
All right. Thanks for having us.
Thank you, guys. All right.